Hello, everyone. You're very welcome to our webinar today to discuss about the draft of the new merger guidelines of the DOJ and the FTC. I'm Tommaso Valletti. I'm the director of the RPN on competition policy of CEPR, and I'm organizing this jointly with Cristina Caffarra. I'm delighted to have incredible speakers from both sides of the Atlantic. So you have the best economists, both from the DOJ and the FTC. They will tell us about the new changes, and then there will be a reaction from this side of Atlantic from Hans Zenger and Mike Walker, so DG Comp and the CMA in the UK. I would like to say simply that this webinar is going to be recorded, and then the recording is going to be made available on social networks, so bear this in mind. The meeting will last for 1 hour, so people won't have time, we won't have the time to get questions live from the audience, but there is a function which is a Q&A, so if you have questions, you can type your questions, and there will be a time for some questions that Cristina will ask to our panelists in the second half of the meeting. So that's all I want to say. Cristina, you can just wave your hand.
Just very briefly, welcome to everyone again. As Tommaso says, it's a privilege to have Susan and Aviv talking about these guidelines, which have created a lot of discussion and controversy. So we look forward to hearing from them. Really an economist discussion, and of course, Hans and Mike to comment on it. So take it away. I think Aviv is going to start.
Indeed. Aviv, the floor is yours.
Okay. Thank you. Thank you, Tommaso. Thank you, Cristina. Thank you for putting this event together and inviting me to speak at it. It seems like we have quite the crowd. I see kind of people continue to enter, and we're quite a large audience, which is great. I think I speak on behalf of both of us. Say we really welcome the interest. Before I start, I just need to provide the usual disclaimer. The views I'm about to express are my own, and not those of the commission or any individual commissioners. So as you know, the DOJ and FTC issued joint draft guidelines on July 19th, earlier this year, a few weeks ago. We are now kind of in the public comment period. So basically until September 18th, we're looking for public comments on the draft, at which point we will sit down, evaluate, think about it, and decide what the final guidelines should look like. So if you're at all inclined, please do submit comments. I'm not just saying that, we really are looking for feedback. And I think an event like this is one of the ways in which we're hoping to generate it. So let me step back a second before going into details to talk about the goals of the revision of these guidelines. And I would say kind of from an economic perspective, I think the main goal was to revise the guidelines to deal, or update the guidelines to deal with realities of the modern economy. Now, what that actually means from an economic perspective, it means sharpening the existing tools that we have, the methods, as well as adding new ones. And I'll kind of talk more specifically about examples of exactly how we did that. Now, I'm sure most of you have studied the document carefully. But with such a large crowd, I'm also sure there's some heterogeneity. So let me just take a second to kind of lay out the structure of the guideline before going into more details. So the guidelines have, several parts. They start with an introduction, which is supposed to be kind of at a high level to be read really by not necessarily antitrust specialists. Then it goes into what I'd say kind of the main heart of the document, which are 13 guidelines highlighting, various potential concerns that the agency might have. The next section is a high-level discussion of market definition, talk about some of the general principles. Then there's a section discussing rebuttal arguments, and it's a very important section, and we'll talk more about it later, and I encourage you as you read the document to look at that section carefully. And next is a 4-part appendix that discusses the tools, methods, and data that are used to explore the various guidelines and the rebuttal arguments in more detail. So a lot of the details, one might say the economic details or the details we would follow in the analysis are in the appendix, but it's important to note that the appendix is an integral part of the guidelines. So to the extent, one of the comments that we got as well by being in the appendix, are these details kind of less important? And from our view, absolutely not. The reason they're in the appendix, and I'll talk more about that later, is for readability and the fact that they're used in different parts, but I'll get to that in a second. Each of the 13 guidelines that I mentioned tends to start with a discussion of the relevant law, whether it's case law or the statute, and then discusses the economic intuition and tries to provide details of implementation. So the idea is to really go from here's the law to here's what the agencies do with that law and what it is that they look at. Many of the implementation details are then again provided in the appendix. And as I've already said, this is really done for readability and to avoid repetition, because some of the same tools are used over and over again at different parts. And if we actually include it in the document, it will either create kind of weird, references from within the document to kind of various, parts, see this section, see that section, or a lot of repetition. So we thought just from a pure readability point of view, it's kind of nice to kind of have them all together, concentrated, organized. We call it an appendix, but really in some sense, think of it as a section 5 of the main document. It really is part of the document. You should not read into anything the fact that it's an appendix. Now, starting with the law and principle is a good idea. I think it really kind of lays out clearly the path from law to economics to implementation. In practice, I have to be honest and say it's hard to achieve, and therefore created, I think, somewhat of a distraction. I therefore, urge you as you read the guidelines to not get stuck in kind of the legal discussion and look beyond it. There's a lot of really good stuff once you kind of get, beyond just kind of that the legal discussion. And I think this is especially true for an international crowd. The U.S. case law, has no jurisdiction outside the U.S., but the general principles of economics, the ones that we use to implement the law, still hold. Or to put it, if you want to put it bluntly, last time I checked, demand curves are downward sloping on both sides of the Atlantic, and the idea is that the general principles that are there hold. So, I really urge you, as you read it yourself, as you read commentary, get beyond kind of that case law, read into the details themselves. There's a lot of good stuff there. And just to be clear, even for a U.S. crowd, the discussion of the law is a good one to have, but I'm not sure that, pushing it in the guidelines, as I said, creates a distraction and kind of doesn't let us really dive into a lot of the good stuff that's there. So let me start talking about the good stuff, and I think there's a lot of good stuff there. So one of the strengths, in my view, of these guidelines is that they clearly lay out the various paths the agencies should explore when investigating a merger. So this really opens the door to bringing in more and new economic ideas. Okay, it has a lot of the traditional ways that we look at economics, but it also has a lot of new ways that really are essential if we want to look at many of the industries and situations that we face in the modern economy. And I'll give examples of this in a few minutes. Another strength that I see is the removal of labels, right? So, for example, we no longer talk about vertical and horizontal mergers per se, although the ideas are clearly there. Rather, what we talk about are the effects, the competitive effects, whether benefits or harm. And I think this is really important in a kind of modern setting where labeling isn't easy, right? You have a transaction, you have a merger, and it has elements of horizontal, elements of vertical. Prior to putting a label, is this a horizontal deal or a non-horizontal deal? I don't think gets us anywhere. Okay? What it allows us to do by not having labels is to get quicker to talking about the substance. Okay, and to me, substance means economics, right? To talk about the harms or the benefits of the deal, it lets us get there quicker without having to worry about, okay, what is the label that we need to put on? So now let me turn to a few specific examples to illustrate these points, and I'm sure Susan is going to follow up with a few more examples from other parts of the guideline. So let me start with the first guideline. And the first guideline is what's called a quote unquote structural presumption. What it does is lays out concentration thresholds. And it basically says that mergers that exceed these thresholds are presumed to lessen competition. Okay? What's the idea here? It's, I think, a pretty intuitive one, right? If I ask pretty much, anyone in the audience, we could take a poll, what merger would you be more worried about? A merger of 10-9 or a merger of 3-2, right? Not knowing much more, you'd probably say, I'd be more worried about the latter, okay? The thresholds are trying to capture that idea, are really trying to capture both unilateral and coordinated effects. Now, some people have tried these type of thresholds, these kind of structural analysis, so-called structural conduct performance paradigm. I don't really sort of see that as the link. I think the general idea is supported by standard models, right? And the intuition I just asked, you don't need to go to models, right? You just ask which of the two cases before you should be more worried about. It's probably the one that leads from a 3-2. Now, if you said, well, if that's all you did, that would be a problem. But that's not all we do, right? We treat this presumption as rebuttable. Okay, what do it's a point we actually need to be probably a little bit clear about in the final guideline. What the point is saying, concentration measures are one thing we look at, but not the only thing we look at. In some sense, it's a starting point, and then we look at sort of other arguments or other kind of discussions to strengthen what we see from the structural case. Now, how do you rebut? How do you push back against this kind of structural presumption? You do that with economic modeling and evidence. And the evidence can focus on either, benefits, right? Looking at rebuttal arguments, so we'll talk more about this later, but also to try to directly address the point that whether, the thresholds that are used might be okay on average, looking across different industries, but are not relevant for the particular deal or the particular merger that's being examined at the time. Okay, and that's where the economic evidence enters. So it's not that there isn't economic evidence; it will still be there and will be start on the analysis. In practice, the higher the concentration or the change in concentration, the more convincing the economic evidence needs to be to really rebut this presumption, right? So if we're actually talking about not even a 3-2, let's say a merger to monopoly in a well-defined market where we actually think there's entry is very difficult, you're going to have a very strong economic argument to convince that deal is not anti-competitive. On the other hand, if it's a less concentrated industry, you could actually see that the burden that you would have to carry in terms of the economic modeling convincing you is going to be much less. Also in practice, it's very unlikely that this guideline, even though it stated that the U.S. agencies might actually decide that the merger is uncompetitive just based on this, it's extremely unlikely they will use this as a standalone basis unless it's in a, very strongly believe in the market definition and the measures far exceed the threshold. Like think of the example I just gave of a merger or monopoly in a market that we really strongly believe is really well defined and that entry is very difficult, and there's no really offsetting efficiency arguments to push back on it. In most cases, what will happen is that this guideline will be used together with other guidelines. Based on conversation I had in the past few weeks, the idea of presumption seems to come to a surprise to some people. But the use of presumption is not new and was very much present in 2010. I mean, if you read the language of 2010, it very clearly states that there is a presumption. The thresholds are a bit different, but the presumption is there. So really the main change here is the fact that the thresholds are simply set, to return to pre-2010 thresholds. But other than that, it really is, there's not a major shift from what was done in practice and in 2010. Now, you might ask, well, if in practice, I just said this is indeed going to be used a combination with another one of the guidelines, why did we just, feel the need to set it separately? I think the answer is that part of what we're trying to do here is to show that there's different channels to challenge a merger, right? And, we'll talk about this sort of later, but, there's going to be a mirror side of saying we're just going to, there's just a structural presumption, but there's also a mirror side of saying we're not going to go and worry about structure at all, or worry, too much about market definition to get that structural presumption and go straight to competitive effects. And to have something symmetric, you almost need to have this as potentially a standalone guide. And similarly, one of the uses I could imagine of this is the cases where the structural case is so strong that we really are going to sort of save resources and can go directly to talking about, well, we don't have to spend as much time talking about, the various elements and models and so forth, and just say, look, the case is so strong that we can actually base a challenge based just on that. Okay. And finally, let me just note that in order to use this guideline, you need probably a fairly narrow market definition. And in some cases, that's actually hard to do. And that's where a lot of times we actually lose cases. Okay, so kind of being mindful of the time, let me just push ahead a little bit and talk about Guideline 2. Guideline 2 states that merger should not substantially lessen competition. The logic here is that any mergers that lessens competition, deprives consumers, or more generally trading partners, whether it's kind of input providers or workers, the benefit of this competition, namely lower prices, more choices, higher quality, innovation, etc. Those who are well familiar with 2010 will notice that we slightly changed the language here. We used to use, there was a use of market power, and instead we're using less than competition. We do this for a couple of reasons. It really helps in connecting with the statute, the US statute, but it also helps us in discussing evidence that hopefully I'll have time to get to. Okay? And the appendix discusses the data, methods, and tools used to measuring of lessening of competition. It includes all the tools and models in 2010 and a few additions. One of the changes I'm personally really sort of like is the discussion of how we explore and present evidence. Okay, and this is the point of kind of how it ties to lessening of competition. Right now, we discuss the gradual presentation of evidence, starting, for example, from documents, from testimony, win-loss data, estimated diversion, maybe a measure of upward pricing pressure, and finally, quantitative models. Think of it as merger simulation. The idea is these are all kind of methods that have been used throughout. We kind of discuss them. We talk about the weight we put on them based on their credibility, but we also emphasize that we use them to learn about ways in which competition could be lessened, which, again, the benefits of that are all the kind of the outcomes that could happen, but that we don't necessarily have to always go all the way to proving the outcomes as you would necessarily, let's say, in a merger simulation. And the answer to that, and the reason we say that is that sometimes it's just not feasible. We don't have the data, we don't have the modeling ability, we don't have the time or the resources. So you can learn about a lessening of competition from a variety of different ways, all of which tell you about the economics. Okay, so all of these are indicative of lessening of competition, but we don't necessarily have to go all the way. And making this point really relies on kind of switching this kind of language to talking about a lessening of competition. As I sort of said earlier, I imagine that in many cases, guidelines 1 and 2 will be used together. However, I can imagine cases where market definition is quite difficult. And that's quite often the case in sort of modern markets, right? Where we're talking about, future products where it's actually hard to even define what the market would be or something else like that. Guidelines 2 allows us to find a broad market and not worry about market definition, and therefore goes much sooner, much faster to the competitive effects. So I know over time, so let me just wrap up and briefly just say Guideline 3, which is about coordinated effects, has some new stuff in it. I'm not going to talk about details, but let me just sort of talk about, there's some discussion of algorithmic pricing and aligning of incentives. I urge you to read those and look at them carefully. There are many other places that we build in the modern economic literature. I know Susan is going to be talking about some of those as well. So let me just conclude that, by acknowledging that these guidelines are still very much a work in progress. We still have some work to do. And I'm not going to sort of talk specifically about what we think, there's going to be changes, but having, meetings like today hopefully will help us get to where we need to get. Thank you very much, and let me turn it over to Susan.
Thank you, Aviv. I just want to mention I checked 20 minutes ago, and on the website where you're receiving comments, already 1,150 comments have been submitted, which is a lot. So this is also because these topics are becoming of general interest, and it's part of the antitrust discussion is clearly not limited to a selected few. That's a very strong democratic signal, I think. But Susan.
Thanks very much. And can you just let me know if the sound isn't good? Unfortunately, my VPN disconnected, so I moved over to my telephone. But hopefully it still works. So thanks to Aviv for that overview. And again, I also want to reiterate that we are definitely very interested in getting comments, and we are certainly going to incorporate changes to the guidelines. So thank you so much to everybody who's already submitted, and please do submit. I want to start by picking up on one of the themes that Aviv mentioned about how presumptions are rebuttable. And that's really maybe one of the most commonly missed things that I've seen in people reading the guidelines. The guidelines are intending to be accessible, and at the very beginning, hopefully a business person who was considering a merger could pick up the guidelines and get the idea of whether they needed an antitrust lawyer, whether they needed to dig in deeper. And it talks about the different ways that competitive concerns could arise. How could a merger possibly lead to a substantial lessening of competition? So the 12 guidelines, they discuss what could be wrong with a merger. But to think about how the agencies would approach overall evaluating a merger, you would look at how competition might be harmed, but also consider, are there reasons that this merger might be helpful to competition? And the rebuttal framework describes this. And one thing I like about the way that the guidelines are now framed is that we can start with how would competition be harmed, but then when we look at rebuttals, those can also be framed in terms of how competition might be helped. And as Aviv mentioned, we have tools such as the tools in the appendix that can be used to assess the nature of competition, to quantify competition, and they talk about how to provide evidence about competition. And those same tools can be used to assess whether a merger could even be helpful to competition. And so, in the rebuttal framework, one important sentence talks about how the merging parties might present evidence that no substantial lessening of competition is threatened by the acquisition. But it also talks about how the parties must show that these benefits that they might be anticipating will pass through to competition. So it's not enough that the merging parties benefit. For example, if you had a cost reduction, if you had 2 weak firms merging, you would need to argue that that merger would indeed make a more competitive industry as a result. And that applies to horizontal mergers, but it also applies to the other guidelines as well. If there's a certain harm to competition that's identified, the merging parties have the opportunity to explain why they think that competition won't be lessened. And so I think it's very important, especially from the economics perspective, to think about the potential harm for competition in the context of this rebuttal framework. Because one thing you might do is come up with a case study and say, well, hey, here's a merger. I think this would be really beneficial for competition. It would make tougher competition. That would lead to lots of benefits for trading partners. But it looks like this merger might be prohibited through these guidelines. And my answer would be no. If that merger improves competition, then the parties would have the opportunity for rebuttal. Now, the rebuttal section also tightens up a lot of loopholes. Sometimes you don't need a merger to get those benefits. And certainly we want to be clear that the benefits need to be merger specific, they need to be verifiable, and we've sort of tightened up the language to make sure that that's not confusing. I don't think the intentions are very different. than the past, but it's, I think, more clear about what it is that the parties would need to do to meet that burden. Then moving on to a few of the other parts of the guidelines beyond the horizontal that Aviv talked about, we have a guideline that talks about a merger that involves a product that your rivals might use to compete. And people will recognize in antitrust insiders sort of the raising rivals cost theory there, and the classic discussions of whether, you know, the merging firms would have the incentive and the ability to harm competition with rivals. By framing it, though, in terms of, not in terms of sort of strictly vertical, it avoids arguing about the geometry of the merger and really cuts to what I think of as the core economics of the problem, kind of avoiding confusion. Moving on to something that's more new, we've brought back into our guidelines the concept of extending or entrenching market power, which didn't receive a lot of attention in the 2010 guidelines. And so there's a number of reasons to elevate this and discuss it in our merger guidelines. First of all, if we maybe starting with an example, what if in the 1990s, Microsoft, instead of building Internet Explorer and then engaging in potentially exclusionary conduct, they had said, oh, what would be even easier is if we just bought Netscape. So you could try to analyze a merger like that under a raising rivals cost theory. But another way to analyze it that might be more, that might hit the economics more head on is an entrenchment theory. And so this guideline about entrenchment would try to start with the market power of the firm, while raising rivals cost is looking at sort of the changes in market power. The entrenchment is really starts with the powerful firm's sources of market power, and then how the merger might entrench that market power. And I think that hits the economics much more head on and really focuses your attention on the heart of the matter. It also, of course, if you have a firm with market power, then presumably there are some barriers to entry, and it focuses the inquiry on those barriers to entry and how the merger might interact with those barriers to entry. So another important point here is that these mergers often do involve related products. And again, the best way to understand the mergers might be in terms of increasing switching costs. Now, when you look at the guideline, it's also useful to see a few important points in the guideline. For example, there's a sentence that highlights that we're not talking about mergers that are simple improvements to efficiency, but rather those that create artificial competitive advantage. And there's a discussion of the kinds of barriers to entry that might come into play here. Again, if you worry that this guideline might say that any high share firm can't buy anybody, I would return to the rebuttal framework to say if this, for some reason, this merger is going to be beneficial for competition, that would be the party's burden to provide evidence that, in fact, the merger is beneficial to competition rather than entrenching monopoly. So transitioning from that, we have several guidelines that are really applications of core concepts from previous guidelines, and I want to talk about two of those. One is the platform section. And I think that the platform section is important for a few reasons. First of all, when we update the guidelines, we want to look out and see what's been happening in the economy. What kinds of mergers have we been seeing that weren't directly addressed or fully enough addressed by previous guidelines? And platforms come immediately to mind. And over the last 15 to 20 years, we have seen several things. First, a lot more mergers involving platforms. Second, we've been able to assess sort of from lived experience, what kinds of barriers to entry seem to be important, and whether platforms are indeed frequently getting displaced, or whether some of them are maintaining dominance over a long period of time. And we can start to understand the sources of that sustained power. And then, of course, when we see this happening in the economy, the agencies learn from their experience, and the economic researchers build both theoretical models as well as conduct empirical work to better understand these. And it's not that it's brand new core economic concepts, but it's rather that, there's details, and we see certain patterns that are worthy of in-depth, detailed study. And so we better elaborate how those economics come to play. Now, in the specific case of platforms, there may be multiple theories implicated in a single merger. You might have something that relates to raising rivals' costs, buying a product that helps your competitors compete, but you might also have entrenchment going on at the same time. And there's also reinforcing effects. So one thing the guideline intends to do is to lay out these economics, which aren't impossible to understand, but involve multiple steps. And it can be difficult in a specific court case to lay out all of those steps, and that puts a lot of burden on the plaintiffs to explain this core economics. So getting us a little bit closer to the economics in the guidelines that would matter then enables the parties in a merger to spend more time discussing the specific facts of the industry rather than having to start from scratch. There's another guideline on labor markets, which also is really an application of core concepts in other parts of the guidelines. I just want to mention and give credit to previous guidelines that the idea that antitrust theory applies equally in buyer markets and seller markets is very clearly laid out in previous merger guidelines in the United States. And we have been successfully bringing cases in that area under the 2010 guidelines, including, for example, the merger involving publishers, where the main theory involved harm to authors who in the market for writing books. And that kind of monopsony case is perfectly consistent with the 2010 guidelines. But over the last 15 years, we've gotten more experience looking at labor markets. And there's also been an explosion of empirical work documenting market power in labor markets. So we've updated the guidelines to be more explicit about how all of these theories apply specifically to labor markets. When I think about the economics of this, it's really not hard. Every textbook, every basic textbook for decades has already laid out the theories of monopsony, and including how they apply to labor markets. And if I think about how that matters for individuals or for me as a consumer, if you think of an example of a hospital merger, if you have two hospitals merge in a city and they're the main employers of nurses, after the merger, they'll recognize that if they expand their employment of nurses, they may have to pay all of their nurses more. So they would, after a merger, have the incentive to hold back a bit on employing nurses. And that change in incentives from the results of the merger would lead to less nurses hired, worse service for consumers, and it also interferes with the whole underlying economic processes. That's how our market economy works. If prices for nurses go up, if wages go up, then people should go to nursing school, or nurses might want to enter this market. But if we interfere with that competitive process, then when I'm old and go to the hospital, I'm going to have not enough nurses, and we're all going to be saying, wow, there's this terrible nursing shortage. What happened? What went wrong? Well, if we didn't allow the market to send the signal to nurses that these jobs are valuable, and then we won't get the entry of nurses in the long term. So it's kind of crazy to me in some way that I have to reiterate that economists would argue with this. This is sort of Econ 101. It's not even Econ 102. But it's not radical, but it's very important. And so I'm really proud of us bringing this to the forefront in these guidelines and making sure that we protect competition in buyer markets and particularly in labor markets. So let me stop there. Thanks very much, and looking forward to the comments.
Wonderful. Thank you very much, Susan. So now we turn to Hans Zenger, Chief Economist team, a former colleague and very good friend. Hans, over to you.
Many thanks, Tommaso and Christina, for the invitation. And I start with the same disclaimer. So I, of course, also speak in personal capacity and not as a representative of the European Commission. So first of all, I think congratulations are in order to the US teams. So well done to get the guidelines out. I know it's it's a tough process to go through a revision of guidelines, and clearly these guidelines are a response to the structural increase in market power that we've seen over the past 40 years. So as we all know, globalization, technological change had a huge impact on the economies and on the market power that we see in our economies. So this time merger control is as important as it ever was, and so in that sense, I think it's very easy to support the U.S. efforts towards a vigorous enforcement of mergers. As Susan and Aviv have mentioned, the guidelines, they significantly expand the scope beyond horizontal. They include lots of interesting stuff on verticals, on conglomerates, on potential competition, dynamic competition, and so forth. And that's great and very exciting that sort of this scope of the potential enforcement is increased. The guidelines, I think they also bring to the forefront a number of really important current competition issues that are, that we're seeing, across the world in modern markets, and maybe saw a lot less in the past. And in many instances, I think these theories that are reflected in the guidelines, they resound quite well with the type of cases that we're exploring and the theories that we're exploring in Europe at the moment. That's things like potential competition, monopoly entrenchment, platform competition, and so forth. One thing I want to emphasize in particular, where I think it's fantastic that there's significant section on this, is extending non-horizontal cases beyond foreclosure. I think traditionally we as antitrust economists, we've looked at non-horizontal cases simply through the lens of foreclosure, because we said, well, there's substitutes that will look at overlaps, and then there's complements that will look at foreclosure. And I think in modern dynamic markets, that's often a too narrow view. Not often, that's sometimes a too narrow view. Because in dynamic markets, the boundaries are often much less clear. And what is a complement today may very well be a substitute tomorrow. And so it's important to assess these sort of ecosystem theories and platform theories and entrenchment of dominance and go beyond foreclosure in specific cases where it's needed. I think it's particularly needed in the circumstances that Susan pointed to, where you have a dominant platform that acquires some complementer that has scarce capabilities arising sort of at the boundaries of what is currently the ecosystem of the dominant firm. Susan mentioned Microsoft Netscape. That's a fantastic example. I think, dominant tech companies, very often, they're not so much afraid of direct head-to-head competition, because in their direct product market, as it is right now, they're protected by entry barriers, by network effects, by scale economies. But what's really dangerous to them potentially in terms of competition is something complementary arising at the boundaries of the moat, and then developing into something else in the future, aligning with other people who are out there, and then dynamically attacking the dominant platform. I think Google is probably a lot more worried about ChatGPT and what people might do with it and how it might be combined with other products than about very direct competition in search in the way search is today. So I think it's amazing to see that in the draft guidelines, and and I very much think that's the right thing. Now, there are obviously quite some different emphasis compared to Commission policy, I would say, European Commission policy. I think it's important to keep in mind in that regard that we have very different legal system. We have different legal mechanisms. So, for instance, the US works a lot more with rebuttable presumptions than Europe. We also have different court environments, which shapes the strategy in which you want to bring cases. So I think there are different institutional dynamics, and I think in large part they explain, the seeming differences in that text to our approach. Ultimately, I think, we will be very much aligned, and I have no doubt that even though we may have different institutional starting points, that we will, in the majority of cases, end up in the same place in Europe and in the US. I will speak a little bit more about implementation, where I have some question marks, and my main comment there really is that this increased, or very strongly increased emphasis on concentration in some of the guidelines or chapters sits a bit uncomfortably with an assessment of competition. I mean, that's particularly true with the non-horizontal mergers. So the way the guidelines are written, they seem to endorse the view that concentration analysis is sort of an end in itself. I guess in Europe we've traditionally, or we do see it more, concentration analysis as a tool, as one way of analyzing competition, but it's just one out of many tools, and other tools are very important to identify anti-competitive conduct itself. It's not an objective in itself. So I mean, it's competition law, not concentration law. So so that huge focus on concentration, I do have some question marks with. Now, Aviv was explaining that nothing really much has changed in that regard, especially with the horizontals, because you had rebuttable presumptions before, and that's obviously true. Yet about some things, I wonder. I mean, the guidelines say, for instance, concentration is problematic even if it arises as a result of competition. So it says efficiencies are not cognizable if they will accelerate a trend towards concentration. I mean, if you mean it differently, maybe it should be formulated differently. So an example I want to give of the question that I have is really, going back, if you think at this retail concentration that we've experienced across the world, in the last 50 or so years, we had all these mom and pop shops traditionally who, then merged a lot. There was a huge increase in concentration and a trend towards chain stores and so forth. And, at least in Europe, I would say that this trend in consolidation has been quite beneficial for competition. These are, a lot stronger and more competitive retailers now who act as purchasing agents, I think, for final consumers. And that's been beneficial, I think, in particular for poorer consumers. So some processes of increasing concentration, I think they're good for competition. And I think focusing too much on concentration loses that out of sight. I will mention non-horizontals as well, where also, at least sort of the main part of the text has a huge emphasis on concentration. And at times it seems to view vertical integration as something that's really inherently bad. And I know that's not meant, because if you look at the individual examples, then, Susan has spelled out some of them, that's all good stuff. It's anti-competitive stuff that you want to go against. But I think some of the language in there, simply gives the impression that vertical integration is viewed as intrinsically problematic. And I think that's not very helpful. What I find great is the stuff on the mechanisms of entrenchment. Susan spoke about the platform competition. I think that's really exciting and very helpful. The more general view on concentration, I'm much less sure. So we have all these technological innovations which in large part result out of integration and may bring substantial value. So we know that there's hardly anything that can be more competitive as integrated guys competing against each other. That's where really the full force of competition can come about. So I have some question marks with respect to these sections. I mean, for instance, when the guidelines speak about using concentration in much the same way for verticals than for horizontals and using analogous methods, I don't really understand what that means. It's it's very different settings. It's substitutes versus complements. So the effect of concentration can be very, very different as we know. So overall, while I personally find there is too much of an emphasis, probably for my personal taste, on concentration as an end in itself, there's lots of great stuff in there. And as I said in the beginning, in particular, sort of extending the scope, to verticals, to conglomerates, to potential competition, to labor markets, and so forth. I think that's a that's a great thing that will help enforcement not only in the US but in the world. And you bring many new topics to the forefront of the debate that have to be debated, and where as agencies we have to do progress. And I believe that we will be ultimately very much aligned in progressing on these very important topics. So congratulations again, and I'm really looking forward to continuing to work with the US agencies on individual cases. Thank you.
Thank you, Hans. I'll pass it to Mike. Of course, there are questions that I'm sure Aviv and Susan will want to add, but let's hear from Mike, and then back to Aviv and Susan, of course.
Great, thank you. Look, standard caveat. Obviously, I'm speaking on my own behalf, not on behalf of the CMA, but I'm not going to say anything controversial, so that's not really an issue. Look, I really like these guidelines, and I really like the approach to the guidelines. I like the fact that the focus is very much on the underlying economic intuition behind the various theories of harm. And I think that actually provides real guidance. I mean, lots of guidelines don't really provide guidance except to the chosen. And so I like these guidelines. I completely agree with Aviv's comment of the value of getting away from labels. Whenever you're having a discussion and you're saying, well, is this a horizontal merger? This is a vertical merger. You're in the wrong place. Just look at the competitive effect. So I really like that aspect of it. Now, I think Aviv and Susan are very careful to try and portray these guidelines as, nothing really to see here. There's nothing really new. It's just standard economics. And look, I agree completely, standard economics. But actually, I don't think that's right. I think there is a substantial break to the past. I think Tommaso said there's more than 1,100 comments have been submitted already. That in itself indicates that something is going on here, and I think something is going on here, and I think it's good. I really don't get the arguments that there's no economics in these guidelines. To me, microeconomics, it's pretty simple. It's not rocket science. It's just thinking about incentives in a straight line, and on that basis, these guidelines do really well. Call me nerdy. Incentives are mentioned 63 times in the text of not particularly long guidelines. It's all about incentive and ability. Think about, do they have the ability to cause harm? Do they have an incentive to cause harm? It's not rocket science. I think it's really good. So I like that, and I think the howls of protest from much of the competition bar are actually a good sign that the guidelines are, broadly speaking, in the right place. Okay. Structural presumptions. So there is, quite a lot on structural presumptions. If we just think about horizontal, I'm largely going to talk about horizontal issues. Hans talked about quite a lot of non-horizontal issues. If we think about horizontal issues, there is basically no mainstream economic model beyond perfect contestability or some extreme auction models that doesn't suggest that increasing concentration in concentrated markets is bad news for consumers. And so on that basis, I have actually no problem with structural presumptions, assuming your market definition is sensible and you're confident of that. And obviously, if we're in a case where there's a huge argument about market definition, then you're not really in the right place. You should ditch the market definition, do the analysis. But otherwise, I think these structural presumptions are good. We don't have structural presumptions in our merger assessment guidelines, but we get pretty close to it. We talk about 4 to 3. It's going to be an uphill battle for you. So I support use of structural presumptions, and I don't really understand why people seem to find the concept of a rebuttable presumption so hard. Susan said that people have read this and missed that, and I'm sort of thinking I'm not quite sure how they're managing to do that, because it seems pretty clear to me. And I think that's the right place to be. It's good economics, and it's also good in terms of enforcement efficiency. Okay. The whole section on talking about extending and entrenching dominance, which Susan said is very different from 2010. I think that's a really important section. The idea that dominant firms might want to entrench their dominant position and do things to protect it, perhaps by extending an ecosystem or whatever. The incentives to do that are really clear, and so it shouldn't be a surprise that competition authorities should be concerned about that. I particularly like the point where the draft guidelines talk about the importance of thinking about this at transition points. Where there might be a technological transition, for instance. And I think Susan mentioned something about ChatGPT. I mean, it occurs to me that certainly with respect to some issues around tech platforms, AI might be such transition point, and so it's super important that we are alive to these issues around existing dominant platforms trying to entrench their positions. So I really think it is good that the guidelines do that. Okay, labour market concerns. I mean, I think this is. I think it's good that this issue is raised in these guidelines. We've been certainly thinking about it within the UK. From my point of view, as to whether some of these concerns are significant in the UK is largely an empirical matter. I've always taken the view that monopoly power, it tends to be associated with downstream market power, so it's captured anyway. Where you're particularly concerned, therefore, monopoly power would be if you have you have labour market power but no product market power. It's an empirical question. My intuition is that's more likely to be an issue in the US than it is in the UK, smaller, more compact country. That said, we are doing work in this area. So we're doing some, our microeconomic unit is doing some research into labour market concentration, markdowns, relationship between concentration and wages, because I think this is a really important area that we certainly haven't done a lot of work on. But one thing I absolutely agree with here is, I think it's just been a terrible blind spot, certainly on my part, but generally in competition policy, I think, to think that monopoly power leads to lower prices upstream, so that must be good because they will get passed through downstream, which is obviously just really bad economics. Monopoly power restricts what you buy upstream, so it's going to restrict your output downstream, and that is not going to lead to lower prices. It might have no effect on prices if you have no market power, but it might increase prices. And so the distinction between, think about labour, maybe wage rates might go down from monopoly power, but actually the marginal cost that the firm faces goes up. That's why they restrict their purchase of labour. Marginal cost goes up. That's bad news downstream. I think that's a really important intuition to make sure that decision makers understand, and we get away from this idea that input market power, it's really not something we should be concerned about. Okay, I've got 1 more minute. Okay, so just a couple of things where I think the guidelines compared to my ideal guidelines are a bit lighter than I would maybe hope. I think it'd be nice if there's a bit more on the importance of innovation and how concerns around harm to innovation, how that relates to a lot of these theories, because of course it does. And I think that harm to innovation is, that's more important, I think, than direct harm to prices. It's lovely to get closer to marginal cost pricing, but actually what we really want is a dynamic economy where we get new products. So I think, I'd be happy to see a bit more on innovation. I'd be happy to see a bit more on resilience. I think one of the things we learned from the pandemic is that we completely ignored resilience concerns in competition policy, and that might be a mistake. We Gavin Thompson and Andrea Coscelli, then at the CMA, wrote a paper on this a couple of years ago. I think the jury's a little bit out as to how we should handle resilience concerns within merger control. But there is a reference to it in the appendix, and I think more work could be done there. And then the final comment I'll make before I shut up is, we made a lot in our merger assessment guidelines of the importance of decision makers being willing to make decisions under uncertainty. And when things are uncertain, not just defaulting to, it's all a bit too difficult and uncertain. Okay, you can do your merger. I don't see, maybe it doesn't need saying in the US, but I think it'd be good to ensure that point is understood, that where we have some of these forward-looking theories of harm, of course they're going to be uncertain, and we shouldn't be embarrassed by that. And I will stop at that point.
Thank you, Mike. Christina, you may want to moderate a few questions, and you may want to throw in a few questions for the speakers and give it back.
Well, of course, I'm sure. Thank you. I'm sure that Aviv and Susan want to react to some of what they heard, but it wouldn't be me if I wasn't also throwing in some sort of comment or provocation on my side, because everyone is being incredibly well behaved, and I appreciate Hans and Mike in trying to be a little controversial. I want to just put this point. Look, both you, Aviv and Susan, are being incredibly conciliatory, right? You know, you're being incredibly reasonable. You're just saying, there's nothing here. Let's not scare the horses. There's nothing to worry about. Really, this is continuity. And look, this is looking pretty much like what we did before. But this is kind of dissonant given what the big reaction has been to this guideline. This guideline has been perceived as a major break with the past, and there's been an outcry. So one part of it, yes, has to do with all the sort of the precedent and the law, and the fact that there is a reference to animating value that go back to the 70s, the references to the case law, Brown Shoe, and you know, Philadelphia National Bank and all that. I mean, leave that to one side. But what has driven this revision is fundamentally a change in the political economy. We need to rethink some of what we're doing, because we've been fairly lax in the past. I think that's a consensus. So I know that, I see you're trying to be reassuring to the rest of the market and to the economists and say, no, we haven't gone crazy. This is stuff that we need to do, but it is all a continuity, it's all there. But it isn't really. I don't read these guidelines as being quite as continuity as you say. I mean, to conclude, the point on concentration is fundamental. I mean, we've been blind to the fact that markets are concentrating serially, and concentration matters. And we've been told that we've been preaching that market power matters, not concentration. Well, I mean, kind of concentration tells you a lot about market power. There will be exceptions. So, I mean, it's a question and a comment. Isn't it less of a continuity message? This is not what comes across to me from the heads of the agency. There isn't a continuity here. There's a bit of a break. And you're just going a little bit out of your way to be sort of conciliatory. I'm with Mike. Embrace it. This is change. And it's good. I'll stop there.
So I can try to take so appreciate your response. And I guess, you know, one way to think about it is that we've had, like, economics has been evolving to meet the reality. Antitrust economics has moved more slowly. I think when people say when they talk about economics, right, it's to a modern research economist who works on imperfect competition, you know, what people are talking about when they say economics is almost unrecognizable from what we do. Like, we study imperfect competition. So I think these, like, rules of thumb that have been used historically just had really big blind spots for the kinds of conduct which led to both a lot of concentration and a lot of market power. And so, you know, one of the things that we're doing, I think, is saying, hey, this modern economics does fit into the antitrust law. And that's scary, because, you know, there's been a lot of market power acquired driving through those blind spots. But at the same time, it's not radical economics, and it does fit into the antitrust law and the antitrust economics. And it's been a bit of a kind of, I think, you know, pulling the wool in front of your eyes, or whatever the best expression is, to say that that those blind spots are definitely blind spots. And again, I also like the point about the labor market competition that was put even more succinctly than I did. In the end, the reason that a monopsonist buys less is because they perceive a higher marginal cost, and that also would be reflected in output markets. Again, that's in every textbook. It's like so simple. You don't even need modern economics, but somehow people pulled the wool over everybody's eyes to say, oh gosh, like, you know, this is, you know, market power and input markets would be good for consumers. So, you know, of course, there are some scenarios it's fact specific. You can construct edge cases, but like the basic economics all, you have to have a more exotic theory to not get that result, that the monopsony is bad up and down the market. So I guess I would just say I think it can be both. It's sort of radical to say that good economics would block a lot of mergers that historically went through.
If I can just jump in quickly, we don't have, I think, enough time for kind of a full response to all the comments. I just want to thank Hans and Mike and Christina for the great comments, if somewhat provocative. I wish we had a lot more time to fully hedge them all out. Let me just kind of reiterate, and my agreement with Susan. I think what we're doing here is simultaneously, this might seem, impossible, but simultaneously continuing, what was done in the past and introducing stuff that's very new. So on some dimensions, I think we are continuing stuff that's in the past. As I said, the horizontal, in horizontal mergers, the structural presumptions were there. We changed the threshold a bit, but not by much. They were there. That's not, a radical change. I think, if I could give an analogy, and it's not a perfect analogy, but if I could give an analogy, the way to what we're doing here with the guidelines, you can think of it as we are building a car. I think we've actually built a very nice car, a car that has a lot more horsepower, also has stronger brakes, right? If you want on kind of both ways of that, maybe has an extra seat to have more passengers in it, and so forth. That's what we've done here in the guidelines. We've extended in various different dimensions. How these guidelines are used, or how past guidelines are used, that's kind of a separate issue, right? And one has to realize that, there's a lot of cases that one could have brought under the 2010 that maybe were not brought, right? So let's kind of separate two different things in terms of what the guidelines are doing, where the policymakers are going to take us. The guidelines are continuing trends that we've seen in economics and kind of extending them in all the various ways that we've done. And my hope is hopefully they'll be used responsibly. But if you're going to use guidelines irresponsibly, just like a car, you can drive a car, you can have a perfectly good car, and then it be driven irresponsibly. What I'm hoping here is that this will be driven responsibly, and I will leave it to you to decide what responsibly means. Right? It could be you're driving it too slow or driving it too fast. Right? That's going to be a matter of policy decision.
Thank you, Aviv. Thank you, Susan. I'll try to wrap up. What I heard is that Susan and Aviv are saying that this is not a big change, it's an evolution. And from an economics point of view, this is perhaps true. It is based on the fact that the world has changed. We are in a different place now compared to where we were 20 years ago. But my guess is also that from a practitioner's point of view, for the kind of economics which is done in cases, not in academia, this is actually a revolution. This is my sense. This is what I feel. I may be wrong, but that's the way I've interpreted things. I remind everybody that there is time until September 18th to submit comments. I'm sure they are welcome, especially they are supportive to the changes that the DOJ and the FTC are putting forward. So please do that. And once again, I thank CEPR. I thank everybody for being on this magnificent.
And Tommaso, if I may jump in to advertise our next event for a second. Hans and everyone on this panel have emphasized the importance of the extension in the direction of ecosystem, entrenchment, acquisition of market power, not through leveraging, but through other mechanisms. So Tomas and I are having an event, and Hans and Mike are also participating in that in a couple of weeks, a workshop in which we're going to talk about precisely that, ecosystem beyond leveraging. So do join if you can.
September 14th. Thanks again to CEPR for this. So thank you, everybody.
Thank you, everyone. Bye-bye.